So good evening. Thank you for joining us tonight. My name is Beth Meyerhoff. I use she, her pronouns, and I'm an attorney with the Women and Girls Rights Project.
Hi, my name is Mallory Sepler-King. I am a senior staff attorney with the Women and Girls Rights Project, and my pronouns are she, her.
Good evening, everyone. My name is Molly Mock. I use she, her pronouns, and I'm also a staff attorney with the Women and Girls Rights Project at Public Counsel.
And we'd like to thank Jessica Monterey, our project assistant, for her expertise and assistance with our program tonight. Next slide, please. Founded in 1970, Public Counsel is the nation's largest provider of pro bono legal services, with over 140 staff annually working with thousands of volunteers to provide free legal services to thousands of people, small businesses, and nonprofit organizations. The Women and Girls Rights Project is one of 8 projects at Public Counsel. We provide free legal services for cis and transgender women, girls, and non-binary individuals for workplace and education-related services. We offer a holistic client-centered approach, which means that we utilize trauma-informed practices supported by staff social workers. In the area of workplace rights, we are defending the rights of low-wage workers to a safe and fair work environment free from exploitation, discrimination, and harassment. We provide direct services, which includes free counsel and advice, advocacy and intervention with employers and schools, representation in administrative processes and litigation. In our advocacy, we are advocating for laws and policies that advance social, racial, and gender justice and support working families. And finally, we provide education and outreach to empower workers and students with information about their rights, which includes community Know Your Rights education. We are striving towards language justice by offering Spanish interpretation for our clients and in our education programs and outreach. We also have a language line that helps us support Indigenous and many other languages. Next slide, please. For today's program, we will discuss anti-discrimination laws, pregnancy accommodations, leave and benefits, lactation accommodations, parenting accommodations, and Title IX rights on campus, followed by a time for questions and answers. And now I'll turn it over to Mallory to talk about anti-discrimination protections.
Thank you. Next slide, please. So to start us off, I'm going to talk about the right to a workplace free from discrimination. Next slide. So all workers have the right to a workplace free from gender-based discrimination and harassment. The Fair Employment and Housing Act prohibits discrimination on the basis of sex, age, gender, disability, race, national origin, and sexual orientation. Pregnancy and new motherhood fall within the scope of protections for gender and disability. Discrimination occurs when you are treated less favorably than other employees based on your pregnancy and related medical conditions. This includes changes to your work conditions, your pay, your schedule, or benefits after disclosing that you are pregnant. Discrimination also includes a failure to provide reasonable accommodations that allow you to continue to perform your job duties during pregnancy, and failure to provide reasonable accommodations while you recover from pregnancy and to allow you to express milk for the duration of the period that you are lactating or nursing your child. Next slide. So as mentioned, during pregnancy, you are entitled to reasonable accommodations in the workplace. Accommodations are changes to your work that allow you to perform your job duties within the limitations you might experience during pregnancy. These can include any of the things listed here, such as changes to your schedule, changes to your work environment, such as a chair when you might otherwise stand, changes to your job duties, and remote work if that is available for your job. Accommodations can also include anything else that you and your employer can identify as a change that will allow you to perform your job duties while staying safe and healthy. To get an accommodation, you should request it from your employer. It's good to do this in writing if you can, but that is not required, and there is no magic language as long as it's clear that what you're asking for is an accommodation. They may ask for a doctor's certification only if the accommodation is for a condition that is not visible, such as a difficulty specific to your pregnancy, but not necessarily universal to pregnancy. Your employer can decide not to give you the exact accommodation that you request, but in that case, they must engage in the interactive process with you to find an accommodation that allows you to do your job. When you learn that you are pregnant or early in your pregnancy, you are not required to inform your employer that you are pregnant, but you should provide them with sufficient notice before you know that you are going to need an accommodation or to take leave in order to allow them to prepare. You cannot be retaliated against for requesting an accommodation. Next slide. So what if your employer discriminates or retaliates against you? What does this mean? If you are treated differently because you are pregnant, that is discrimination. If you request an accommodation and then are fired or have your pay reduced, that is retaliation. Both of these are illegal. If you experience these things, you have the right to talk to a lawyer, file a complaint with a state agency, or file a lawsuit. You can always reach out to public counsel if you have questions about these rights. We have a workplace rights advice clinic every Wednesday. Jess will drop a link to that clinic in the chat if you are interested in signing up for an appointment. Please take a look and know that we are here as a resource if you do have questions about your rights. Next slide. So the next topic that we are going to cover is your right to accommodations after you give birth, specifically related to lactation or nursing. Next slide. So if you are a person who is lactating, your employer is required to provide you with reasonable accommodations, just like with pregnancy. So you are entitled to reasonable accommodations in order to express milk. You do not need to provide a doctor's notes to get these accommodations. You are entitled to accommodations for as long as you are lactating or nursing. There is no time limitation on your right to this accommodation. So these accommodations include giving you breaks as needed to express milk or pump. You can use your regular breaks to do this, in which case they'd be paid, or these can be in addition to your regular breaks. In that case, they may not be paid. The breaks must be long enough for you to do everything you need to, including setup and cleanup. And there's no set time limit for how long the breaks can be, but the standard is a reasonable amount of time. So if you're finding you need more time, work with your employer, just make sure you're communicating. Next slide. So your employer must, if possible, also provide you with a place to pump. For most employers, they're required to provide you with a clean space with a sink, a place to sit, a locking door, access to electricity, and also with reasonably easy access to running water and a refrigerator. This location cannot be a bathroom stall or bathroom. Next slide. So what do these accommodations look like in a practical sense? If you work in an office setting, this may be a designated lactation room or small office, a conference room, or another space that meets the criteria we just discussed. Remember, this cannot be a bathroom, and even if the space that they designate as the lactation space is usually a common space or a shared break room of some kind, it must be free from intrusion, and its use as a lactation space takes priority. So when you need it, you get to lock the door. It's for your priority use. Nobody else can barge in. If you work in a non-office setting, this can be a little trickier given the work conditions and depending on your work type. However, employers of 5 or more employees are still required to make a reasonable effort to accommodate nursing parents. This can require some creative thinking, but it could include a temporary space, such as setting up a barrier, an air-conditioned car or truck with window coverings, or a pop-up tent. In those cases, a cooler should also be provided to store milk, as well as access to electricity is still required. If you work in a multi-tenant office building, similar to a normal office setting, your employer is required to provide you with that space, but in that case, it could be shared with people who are working in other offices. They should work with you to set up a schedule to make sure that it's available to everyone as needed. If you work as a subcontractor, you should advise your employer or general contractor of your need for lactation accommodations in writing as soon as you can. Your employer or general contractor must provide accommodations within 2 business days of your request. So I'm going to hand it off to Molly now. As a reminder, if you have any questions, please use the Q&A feature and we will get to those at the end of the presentation. Thank you. Next slide.
Thank you, Mallory. Now we are going to talk about leave and benefits. A note for our Spanish speakers: throughout this presentation, we will be using the word leave to refer to a permission to be off of work. Next slide, please. There are two main types of leave that a pregnant person can take under California state law. The first one that we're going to talk about is pregnancy disability leave. A pregnant person can take pregnancy disability leave once they are actually disabled by pregnancy, which could also require doctor certification. Pregnancy disability leave is up to 4 months of job protected leave for pregnancy or childbirth related disability. The time period is up to 4 months, but only for a period when you are disabled by pregnancy, which can mean unable to work or advised by a doctor not to work due to your pregnancy. Pregnancy alone, however, is not a qualification. You won't qualify for this leave because of pregnancy alone. You have to be disabled by your pregnancy. Typically, pregnant employees will start their leave around 1 month before their due date, but it can be earlier depending on the employee's health and circumstances. For example, an employee may be considered disabled by pregnancy if they are suffering from severe morning sickness, experiencing gestational diabetes or hypertension, requiring time off for doctor-ordered bed rest, or have complications from childbirth. This leave applies to all California employers with 5 or more employees, and there are no minimum hours or time on the job requirements to be able to take this leave. This pregnancy disability leave is unpaid, and that means your employer does not have to pay you during your leave unless your company policy or collective bargaining agreement says otherwise. However, you could be eligible for some wage replacements under certain state benefits programs, which we're going to talk about in a little bit. This leave is job protected, which means that your employer can't fire, demote, or otherwise retaliate against you for taking pregnancy leave, and you are entitled to return to your job when your leave ends. Next slide, please. Pregnancy disability leave may be used intermittently during pregnancy, including for prenatal care like medical appointments, any complications, and morning sickness. You should also have a continuation of your health benefits while you're out on this leave. And pregnancy disability leave can continue after birth as well. Pregnancy disability leave also runs concurrent with any leave under the Federal Family Medical Leave Act. Additionally, as an alternative, employees can use their California paid sick days to handle pregnancy-related needs. Full-time workers in Los Angeles are guaranteed a minimum of 6 sick days per year. State law currently requires at least 3 if you're outside of Los Angeles area. There's also currently a bill being considered by the California State Legislature that would expand paid safe and sick days to 7 days statewide. This bill is called Senate Bill 616 if you're interested in following that progress. Otherwise, stay tuned for updates after this legislative session. Next slide, please. You can apply for state benefits, specifically state disability insurance benefits, also known as SDI, from the State Employment Development Department for pregnancy and childbirth when you take pregnancy disability leave. All workers who pay into the State Disability Insurance Fund are eligible for these benefits. If you're not sure if you're paying into this fund or not, you can check your pay stub. And if you see a deduction from your wages that's labeled SDI or CASDI, then you are eligible. The benefit is that you get up to 60 to 70% of your wages replaced up to a certain maximum. Generally, this can be for 10 to 12 weeks, but it can be longer, for example, up to 52 weeks. The first week of leave under the state disability insurance benefits is unpaid. Next slide, please. There has been a recent legislative update under a bill passed last year, SB 951. Starting in 2025, low-wage workers will be able to receive wage replacements for up to 90% of regular pay for the first 16 weeks of state disability insurance benefits. Next slide, please. Another type of leave that you may be able to take is bonding leave under the California Family Rights Act. If your pregnancy disability leave runs out, then you can take bonding leave under the California Family Rights Act after your child is born or joins your home if you're adopting or fostering. You can take up to 12 weeks of job protected leave. Baby bonding leave in California is available to both parents during the first year, and it also applies to parents of newly adopted children and newly placed foster children. Parenting, this baby bonding, and also known as parental leave, can also be taken over time or intermittently during the first year. It does not have to be taken all at once or immediately after the period of pregnancy disability ends. To be eligible for leave under the California Family Rights Act, your employer must employ 5 or more employees, and you must have worked a minimum of 1,250 hours and have 1 year on the job. It is unpaid leave. However, it has the same job protection and benefits as the pregnancy disability leave that we just talked about. Next slide, please. You can also take other types of leave under the California Family Rights Act in a variety of circumstances. However, notably, under the California Family Rights Act, it does not consider pregnancy alone as a serious health condition. So keep that in mind as we talk about these other types of leaves. We just talked about bonding leave, which you can take to bond with a new child. But you also can take leave under the California Family Rights Act to care for your own serious health condition, like potentially recovering from birthing complications, as an example, as long as it rises to the level of serious health condition under the law. You can also take this leave to care for the serious health condition of a family member. A family member can include your parent, your spouse, domestic partner, child, grandparent, grandchild, sibling, parent-in-law, or a designated person. And speaking of a designated person, there was a recent legislative change in 2023. Starting in 2023, employees can use some or all of their 12 weeks of California Family Rights Act leave to care for an additional designated person with a serious health condition. A designated person can be anybody related by blood to the employee, such as your aunt, uncle, or cousin. A designated person can also be a person who is like family, for example, an unmarried partner or a best friend when that relationship is equivalent to family. The employee must identify the designated person at the time of the California Family Rights Act leave request. However, employers have the right to limit employees to using that leave to care for only one designated person during any 12-month period. And finally, for clarity, we've talked about these two types of leave, but only pregnant employees can take pregnancy disability leave. However, both parents can be eligible to take bonding leave under the California Family Rights Act. Next slide, please. Similar to the pregnancy disability leave, persons who take unpaid leave under the California Family Rights Act can apply for benefits under the state's paid family leave program. Paid family leave, essentially all workers who pay into the fund are eligible for these wage replacement benefits. And these benefits are, again, up to 60 to 70% of pay. And this leave can be up to 8 weeks, and both parents are eligible. Both parents can take leave at the same time or separately. And also, just as a reminder, starting in 2025, specifically January 1st, 2025, low-wage workers will be able to receive up to 90% of regular pay under the Family Paid Leave program. Next slide, please. Now let's go through a scenario. What if you need to take leave for your pregnancy? Here we have Diana, who's 7 months pregnant, and she would like to take leave to give birth, recover, and bond with her child. Can she take leave? Is Diana's job protected while she's out on leave? Can Diana be paid while she's out on leave? All excellent questions, and I will have you all think about it for 1 minute before we talk about Diana's options. Next slide, please. So can Diana take leave, and is her job protected? If Diana is actually disabled by her pregnancy, she can take pregnancy disability leave, which is job protected. She may also need a doctor's certification to be able to take this leave. And Diana can also take leave under the California Family Rights Act to bond with her new child. Again, California Family Rights Act does not consider pregnancy alone to be a serious health condition. However, if there's any complications with Diana's pregnancy, she may be able to take leave to care for her own serious medical condition if her medical condition rises to the level of serious under the law. And can Diana be paid while she is out on leave? Diana should definitely check her employer's policies or her collective bargaining agreement to see if her employer has any obligations to pay her. However, generally, employers are not required to pay an employee while they're out on pregnancy disability leave or California Family Rights Act leave. She could, however, be eligible for wage replacements under 2 benefit programs that we talked about. She can apply for state disability insurance for up to 60 to 70% of wage replacement while she is out on pregnancy disability leave. And she can apply for paid family leave benefits for up to 60 to 70% of wage replacements while she is out on bonding leave under the California Family Rights Act. Next slide, please. And I will now pass it on to Beth.
Thank you. Now we'll talk about parenting accommodations. Next slide, please. Many workers are also caregivers for other people. California law allows employees to designate some of their sick days for what is called kin care leave, also known as protected sick leave law. This is time off of work to care for a family member, and this includes sick children. An employee can use up to half of sick leave for specific family members, and it can be for the care for a family member who is ill or needs a medical diagnosis, treatment, or preventative care. Family member for purposes of kin care is defined to include an employee's child, parent or guardian, spouse or registered domestic partner, grandchild, grandparent, and sibling, but does not include in-laws. As was previously discussed, using paid family leave is an option for workers who pay into the state disability insurance SDI program. Molly previously discussed paid family leave for bonding with a child. This leave is also available for workers who need to take time off of work to care for a sick child. And just a reminder that paid family leave provides benefit payments or money, but not job protection. Your job may be protected by other laws, such as the Family and Medical Leave Act or the California Family Rights Act. And the California Family Rights Act provides job protection for up to 12 weeks. And as discussed earlier, it can be used for the serious health condition of a family member. And starting this year, you can name a designated person as your chosen family for purposes of CFRA, which is any individual related by blood or whose association with the employee is the equivalent of a family relationship. To use these benefits, you may request leave directly from your employer. Next slide, please. The law protects you while you are using these leaves. California Healthy Workplaces, Healthy Families Act. This refers to sick leave. This ensures that most employers provide employees with paid sick leave. The law also protects you if you're using California Family Rights Act, the CFRA leave. If you are fired or otherwise penalized for using these leaves, contact public counsel. Next slide, please. California law entitles employees to take up to 40 hours off work each year for their children's school activities. The Family School Partnership Act allows parents or people who are guardians, step-parents, foster parents, or grandparents to take time off from work to participate in their children's school or child care activities. The provisions were added to add licensed child daycare facilities to the kindergarten through grade 12 levels included in the original legislation. This law applies to employers with 25 or more workers. The time off is generally unpaid unless an employer has an alternate policy in place, or an employee may request to use existing vacation or personal days for pay. Employees may take leave to participate in school activities of the school or licensed child care provider of a child, find, enroll, or re-enroll a child in school with a licensed child care provider, or address a child care provider or school emergency. Only 8 of the 40 hours may be used to find, enroll, or re-enroll a child, and you must provide notice to the employer if possible. Next slide, please. What if you need to appear at school due to disciplinary issues? School appearance leave applies to all employers regardless of size. Under the school appearance leave requirement, an employer cannot in any way discriminate against an employee who takes time off to appear at school in conjunction with a child awards suspension from a class or school. The law does not require the employer to pay the employee for the time away from work, so on the day that the employee leaves to go to the school, the employee is paid for the actual time spent working. Next slide, please. School closures can happen in a variety of situations. For example, some parts of our state are susceptible to wildfires, which can require school closures, or recently, the rain and snow might have affected school openings, or sometimes there's a disease outbreak. We just discussed the Family School Partnership Act, which allows parents or people who are guardians, step-parents, foster parents, or grandparents to take time off from work to participate in their children's school or child care activities. This could also be available for school closures. Some other options employees can explore are paid sick leave. If you become unemployed due to your child's school being closed, an employee might be eligible for regular unemployment insurance benefits as well. Next slide, please. What rights and benefits can workers receive if they are undocumented? All workers who have paid into EDD or the Employment Development Department are eligible for benefits regardless of documentation status. Employees would have money withheld from their checks each month. Employees would be eligible for SDI, state disability insurance, and paid family leave. The EDD operates both of these programs. One way to think about this is paid family leave is like SDI, but for caregivers. So state disability insurance is the money for workers unable to perform normal work because of their own non-workplace injury or illness, with a 7-day unpaid waiting time, and the California paid family leave is 8 weeks within a 12-month period with no waiting period. Employees apply at the EDD office either online or by requesting a paper form. The online version requires a Social Security number. Undocumented workers are not eligible for unemployment insurance. Next slide, please. And now we'll talk about Title IX rights on campus. What is Title IX? Title IX is a federal law that prohibits discrimination on the basis of gender on school and college campuses. It is only 27 words long, and it reads, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance." So who is protected? Every student, school staff, faculty, visitors, and any other people on a campus that receive any form of federal funding. Title IX operates on the grounds that sex-based discrimination in education creates a hostile school environment. And that's when the environment interferes with or limits a student's ability to participate in or benefit from school. Title IX is a civil right. All schools receiving any form of federal funding are held to Title IX, and schools must take continuous action to ensure that there is not a hostile environment on campus. It applies to all students regardless of gender identity, and schools cannot retaliate against and must prevent harassment against someone filing a complaint. A school must share or make available its policies on sexual harassment and sexual assault with every student, teacher, and staff member. And the school must also provide students with information about how to report sexual violence or harassment, known as a grievance procedure. And this policy should tell you what happens after you report, including how the investigation will go. Next slide, please. So in general, Title IX prohibits discrimination on the basis of a student's actual or potential parental, family, or marital status, or pregnancy, childbirth, termination of pregnancy, or recovery therefrom. Any student that might be, is, or has been pregnant still must be given the equal opportunity to participate in any school-related program or extracurricular activity. Students who are pregnant or recovering from pregnancy are entitled to accommodations. So any services or accommodations given to students with temporary medical conditions must be given to pregnant students. So for example, if a school provides homebound instruction or take-home assignments to students who miss school for illnesses, they must do the same for a student who misses school as a result of pregnancy or childbirth. Optional classes and programs offered to help pregnant or parenting students must be open to other students. Students can choose to participate in special instructional programs, but cannot be required to do so. Now let's talk about some pregnancy accommodations. Next slide, please. So campus accommodations can include a right to attend class. Pregnant parenting students cannot be stopped from attending a class, and students cannot be forced to take time off. Medically necessary absences are excused. Title IX requires schools to excuse absences. Students must be allowed to take time off of school for pregnancy, childbirth, miscarriage, abortion, and or recovery for as long as their doctor says is medically necessary. And this rule applies even if taking medically necessary leave would require an absence for longer than the school's leave policy ordinarily allows. Excused absences must be related to pregnancy or childbirth, and they must be considered an excused absence with a doctor's note. And students must be allowed to make up work. So if points and awards are given based on class attendance, the student must be given the chance to earn or make up the credit. And they must be allowed to reschedule exams if missed because of pregnancy or complications from pregnancy. If grading is based in part on class participation or attendance, and a student missed class because of pregnancy or childbirth, the student should be allowed to make up the participation or attendance credits that they didn't have the chance to earn. Equal inclusion in school activities. A school must allow a student to continue participating in classes and extracurricular activities even though they are pregnant. This means that they can still participate in advanced placement and honors classes, school clubs, sports, honor societies, student leadership opportunities, and other activities like after-school programs operated at the school. A school can only ask for a doctor's note for activity participation if they require a doctor's note for all students with medical conditions. Students are entitled to private accommodations for breastfeeding, which means access to a private area that is not a bathroom where they can express breast milk, and reasonable breaks must be given during educational programming. Scholarships cannot be terminated or reduced, and then student status cannot be impacted. Students cannot be penalized for taking leave and must be able to return to school in the same status they held before taking leave. Other Title IX accommodations include physical accommodations, for example, providing students with reasonable adjustments like a larger desk, elevator access, or allowing students to make frequent trips to the restroom when necessary because of pregnancy. And finally, a school must have a process for requesting accommodation. Now let's look at an example. Next slide, please. Rachel is an undergraduate student and has had to miss classes regularly and an exam due to her doctor's appointments and pregnancy complications. What are her options for making up missing classwork and the exam? What physical accommodations could be available to her? Next slide, please. Rachel can request extensions on her homework and classwork deadlines. She can request to reschedule the exam. She could also request alternate assignments, including extra credit coursework to make up for the missing classwork. And some other options could maybe include reducing her course load or changing her classes to pass-fail. Her physical accommodations could include a larger desk, elevator access, and more frequent restroom breaks. And these accommodations are also available to workers. And now I will turn it over to Molly.
Next slide, please. So we're going to get to the question and answer shortly. So please, if you have any questions, use the Q&A box and we'll try to get to all of them. But I also wanted to take this time to highlight our weekly workplace rights clinic. Jess will drop a link to this in the chat, or you can find it through Public Counsel's website by visiting the Women and Girls Rights page. This workplace rights clinic takes place on Wednesdays, and you can sign up for a time to speak to one of our attorneys between 4 p.m. and 7 p.m. So if we don't get your question today, or you'd like to speak to us further about an issue you may be having at work, we would encourage you to sign up for an appointment and speak to us. I also wanted to note that when you close this Zoom, a short survey should pop up, and we would really appreciate it if you take a couple minutes to fill it out. And I think there's only about 4 or 5 questions. It should be relatively quick. So now we're going to get to the question and answer. We only have one right now. What if your employer makes you move your space with no notice? And I believe this question is referring to lactation space. So Mallory, what would happen?
Yes, so this question did come in right at the end of the lactation section, so I'm assuming that this is asking if you are given a lactation space and then that is changed without notice to you, what would your rights be? So it would depend on the exact circumstances of how this happened, but in general, if they want to change your designated lactation space at work, they must provide you with an alternate immediately if you need one immediately, that is equally sufficient. So you can't be left without a space even for like part of the day if it's going to disrupt your pumping schedule. If there are more specifics about this is something you experienced, or you want more specifics about how this might apply in different circumstances, please, I would encourage you to schedule a call with our clinic, and we'd be happy to sort of talk through more specific situations.
And a follow-up to that is, what is the cost of the Workplace Rights Clinic?
The Workplace Rights Clinic is free. So yeah, you just make an appointment with us. There are several scheduled or time slots available every Wednesday, and it is completely free. We'll provide you with whatever advice that you can and talk to you about your other options going forward.
One of our viewers is in Florida. Would these family leave laws apply?
So some of them would. One of the things that Molly talked about is the California Family Rights Act. Federally, a lot of those same rights are provided under the Family Medical Leave Act, FMLA, but there is a little bit higher threshold. So in California, you only have to have 5 employees at your employer in order for that law to apply. I believe for the federal law to apply, it is 50. I hope I'm getting that number right. But it is a greater number of employees. So if you're at a very small employer, that same right not apply, but otherwise you should have those same rights to take protected leave to care for yourself or a sick family member, or to welcome a new baby.
So I don't see any more questions in the Q&A box. We have a couple more minutes if anybody has a burning question they'd like to talk about. Otherwise, our clinic line is open. Again, Wednesdays from 4 to 7. Please come talk to us. I'd also like to take this time to thank you all who came and participated today. I want to thank our wonderful interpreters, the Audrey Ermis Women and Girls Rights Project team, and the Public Counsel Communications team for all the efforts put into this event. We'd also like to thank the Audrey Ermis Foundation for all of their support and the funding to make this presentation happen today. And so I don't see any more questions, so I hope that you all have the information you need. Otherwise, you know where to find us. So we'll give you 5 minutes or 10 minutes back of your evening. Have a wonderful evening, everyone.